Welcome to our clients and friends for this special effort in partnership with the ACC Southern California Corporate Counsel Group. My name is Bill Martucci, and I, like my wonderful colleagues, are very thankful to have this opportunity to be with you during these very challenging times. We know you are addressing a lot of difficult issues, and we are hopeful that our focus on COVID-19, California, and federal employment law considerations will be helpful to you in that way, in a very pragmatic, strategic focus. Among the topics we'll discuss, and there are many, are recent legislative and regulatory developments, managing through furlough and employment programs, remote work aspects, California wage and hour considerations, the WARN Act and special considerations in California under the mini WARN in California, the CARES Act, and those questions that come up with California shelter-in-place orders. We will have the opportunity toward the end to get into questions and answers, and there is a place on the screen to raise questions, and we will do our best to address those. So thank you again so much for being with us, and we're going to begin with my colleague Elizabeth Lee from our San Francisco office and Laura Booth from our Orange County office.
Thank you, Bill. Hi, everyone. Thanks so much for joining us today. First, we are going to cover the Families First Act. I'm going to first talk about some amendments that have come up under the FMLA, and then after that, I'll pass it off to Laura, who will discuss some updates regarding sick leave provisions. First, to give you an overview, under the Families First Coronavirus Response Act, there's an Emergency Family and Medical Leave Expansion Act that has gone into effect this week, just yesterday, and it will be in effect until the end of the year, December 31st, 2020. This portion of the Act focuses on providing expanded family and medical leave for employees who are now in a position of needing to take leave in order to care for their children, whose schools or places of care have been closed, or whose childcare providers are otherwise unavailable due to a coronavirus-related reason. These provisions apply to private employers that have fewer than 500 employees in the United States. That covers general employees and extends to employees that are jointly employed by other entities. However, it does not encompass independent contractors. And with respect to the employees that are covered under the Act, it applies to full-time or part-time employees who have been employed with the company for at least 30 calendar days. Under the Act, the compensation structure is based on the number of hours that the employees would have normally worked during a given work week. There are a total of 12 weeks of leave available under this Act. The first 2 weeks are covered by full sick pay, and then the subsequent 10 weeks will be paid at 2/3 of a person's normal pay. And all of these are calculated based on the employee's regular rates of pay and the number of hours that they would typically work during a given week. It's important to keep in mind that employees under the Act can seek to supplement the expanded leave. For example, they could request to cover the remaining 1/3 of their full pay using other leave that's available under your company's policies. However, at the same time, there is a cap on the amount of pay that will be provided, which is $200 per day or $12,000 over the course of the 12 weeks. And it's another key point is that premium pay for overtime does not need to be provided under the Act. Given that the calculation is based on the regular rate of pay, which does vary based on the employee's experience with the company and the type of schedule that they've had so far. This is a chart that breaks down some of the key considerations here. You'll see, for example, an employee who's been employed with the company for a while their schedule will be determined based on the number of hours they typically work in a 2-week period and the average rate of pay that they've had over the last 6 months. In comparison, if you have an employee who's been with the company for less than 6 months, you'll look at the number of hours that you and the employee have generally agreed that they'll work and the regular rate of pay that they've had for each week with the employer. And based on that, you can calculate each person's compensation under the Act. Again, it's important to still keep in mind that any of the regular rates of pay must still comply with federal, state, and local minimum wage requirements, and that any commissions or tips or other additional compensation should be included to the same extent that they are considered under the Fair Labor Standards Act. In deciding whether leave is appropriate, you can keep in mind that there are certain limitations to the extent leave is available. Again, because the purpose of the Act is to provide leave for employees who need to take time off in order to care for children who cannot go to school or cannot otherwise receive outside care. So, for example, if your company has generally shut down operations for other reasons because of a lack of work at this time, that would be a situation where employees would not be entitled to paid leave. Similarly, if you're working with your employees to do alternative work environments or work schedules, such as teleworking or adjustments to their typical work schedule, but they're still able to work, then they also would not be entitled to leave under the Act. And there are some other limitations on that as well. However, even if employees are not eligible for paid leave, it's important to still consider that they might be entitled to unemployment insurance benefits. Next, just some, for your purposes in preparing to provide paid leave, it's important to keep in mind that certain record-keeping obligations do exist. Employees must hold on to any notices or other proof that their child care provider or school has been closed. And then once they present those to you, it's important to keep those filed and saved so that you can reference them later on in accordance with regular FMLA leave request certification requirements. Similarly, there are documentation requirements if you would like to obtain tax credits for the services, for the leave that's being provided. Again, those are in place and should be followed if you would like to obtain tax credits. And now I'll pass it over to Laura, who will cover paid sick leave.
Thanks, Elizabeth. This is Laura Booth, and I am also going to be talking about the Families First Coronavirus Response Act, but particularly with regard to the Emergency Paid Sick Leave Act. And the Emergency Paid Sick Leave Act essentially provides workers with up to 2 weeks off at full pay, subject to certain caps, if they're directly affected by the virus, and partial pay if the employer needs to care for affected family members. Similar to FMLA, this applies to private employers with fewer than 500 employees, as Elizabeth discussed. This, again, is effective as of April 1, yesterday, and as it stands now is effective through the end of the year, December 31st. Unlike FMLA, there is no waiting period or accrual. An employee may qualify immediately for the Paid Sick Leave Act. And of course, the Sick Leave Act information must be posted at the place of employment. The Department of Labor website does have a downloadable poster if any of the employers need that. Oh, excuse me. Okay, there is an exemption for small businesses with less than 50 employees, so I want to go over that briefly. The exemption provides that an authorized officer of the business must determine that the paid sick leave falls into one of three buckets. One is that the paid sick leave provision would cause business expenses and financial obligations to exceed revenue and cause the business to, quote, cease operating at a minimal capacity. Number two, the absence of any workers who request paid sick leave will entail a substantial risk to the company's financial well-being or ability to operate because those persons possess special skills, knowledge of the business or responsibilities, or not enough qualified workers would be available to do the work requesting paid sick leave, to do the work employees requesting paid sick leave perform if that work is necessary for the company to run at minimal capacity. As you can see, this is largely subjective, and there's not really clear governance on this provision at this time. With regard to the employees eligible for emergency paid sick leave, an employee can qualify under any of the following reasons. One, the employee is ordered to quarantine or isolate by federal, state, or local authorities, or if the employee has been advised by a healthcare provider to self-quarantine, if the employee has symptoms consistent with COVID-19 and is seeking a medical diagnosis, or if the employee is caring for an individual who is subject to federal, state, or local quarantine or isolation order, or if the employee is caring for his or her own child because the child's school or child care center is closed, or because the child care provider is otherwise unavailable due to COVID-19 precautions. This also applies to full-time employees with regard to pay calculations. So employers must pay employees at their full wage if they are taking time off for themselves, or 2/3 of their regular pay if they have to care for a family member or child, up to certain caps. So full-time employees, those of employees who are scheduled to work 40 hours or more a week, are entitled up to 80 hours maximum of paid sick leave. Part-time employees are those normally scheduled to work less than 40 hours per week, and they are entitled to pay for the average number of hours worked over a 2-week period. That, again, as Elizabeth discussed earlier, that would be the employer, the hours the employee normally works, or an average from the prior 6 months. And with regard to the pay calculations, if an employee is taking leave because of their own personal COVID-19 diagnosis, or because they are themselves subject to a local, state, or federal quarantine order, they will receive their regular rate of pay, well, the greater of their regular rate of pay, federal minimum wage, or applicable state or local minimum wage. However, that pay is capped at $511 per day, or a total of $5,110 for the entire 2 weeks. And if the employee is taking leave for any other reason, like caring for another individual who has COVID-19 or their child, then they will receive 2/3 of the greater of the amounts above stated, the regular rate of pay or minimum wage. And their pay is capped at $200 per day, or a total of $2,000. And again, there is no need to calculate overtime premium for any of those. Just a couple of exclusions and limitations. Healthcare providers and emergency responders may be excluded from these rules at the discretion of the Secretary of Labor. Also, the Department of Labor has stated that workers won't be able to avail themselves of the paid sick leave options in Families First Act during any period in which their employers are closed, no matter how long. And again, as Elizabeth stated earlier, that's due to either lack of business or because the business has been required to close because of a local or state directive. Employers may not require that an employee search for or find a replacement employee to cover the hours in which they're going to be gone for their paid sick leave. Also, an employee may not take a paid sick leave for themselves because they have been diagnosed with COVID-19, and then again because of taking care of somebody else. It's a total of 2 weeks or 10 days of paid sick leave for any combination of the qualifying reasons. And it's also not retroactive. So the paid sick leave is effective beginning April 1st. If an employee has previously taken sick leave, they are entitled to another 2 weeks starting yesterday. And that's a brief overview of the paid sick leave. And next I will turn it over to Kristen Page.
Thank you, Laura, and hello, everyone. Moving on from that very helpful discussion of the Families First Act, we're now going to talk just a couple of minutes about furlough and employment termination programs and some ideas around managing through them. Of course, furloughs and job loss programs are those that many are considering and facing during this time. Taking furloughs first, on this next slide, we've got listed some considerations that should be thought through in this process. So first, in thinking about legal risks and requirements with furloughs, we need to define the type of furlough that we're thinking of. Furloughs can be continuous, meaning a person is not working for some continuous period of time, say several months in sequence, or furloughs can be so-called intermittent, like a reduced work schedule. And the furlough type relates to some of the legal issues that might arise. So in the context of intermittent furloughs, special attention must be focused on exempt employees. So we're going to talk about that for a few minutes. We know that exempt employees generally must be paid their full salary for each week in which they perform any work, and subject to some limited exceptions, if an exempt employee performs any work in a week, that employee needs to be paid his or her full weekly salary. So if an employee is furloughed and performs any work, like even modest activities like perhaps briefly checking email or answering calls, the employer must pay that employee his or her regular weekly salary for the full week. And then likewise, if an employee works only 1 or 2 days out of a work week, they still must be paid the same weekly salary. If an employer fails to comply with this rule for exempt employees, the exempt status of all employees subject to that practice can be jeopardized. And of course, looking at the flip side of this, exempt employees do not have to be paid for any work week in which they perform no work, including weeks for which they've been furloughed. And so because of this, employers considering intermittent types of furloughs for exempt employees would be best to do so in 1-week increments and to take strong measures to prohibit both exempt employees and, of course, non-exempt employees, if you're affecting that group as well, from doing any work during a furlough period. And so this likely means advising all employees that are in the exempt category that they're not authorized to perform any work, and also, again, in the non-exempt category during furlough periods, and that any such work requires prior approval. We also think it's wise to consider cutting off system access for furloughed employees during their furloughs, and also advising supervisors, coworkers, and others to not contact those employees during such times. We say all this just because of the importance of the exemption and not having anything happen during an intermittent furlough that would put the exemption at risk. In the furlough context, employers should also keep in mind reporting time pay in California. If employees are required to show up for work and are then furloughed, they might be entitled to 4 hours of reporting time pay. So that's another issue to keep in mind. Another relates to benefits. We've listed here benefits eligibility requirements. Very important to check benefit plans when you have a furlough being contemplated to ensure eligibility requirements are still met as it might be contemplated by those subject to a reduced work schedule. And then finally, and this is not intended to get into the immigration area deeply, but good for employers to consider in the furlough context any limitations on schedule and pay changes related to sponsored foreign workers. So moving on to the next slide, which highlights a few points around closures, layoffs, and job loss. There are many, many issues, of course, to be considered in this context, and we're truly just going to mention them here. A few of our later speakers will cover some of these areas in greater detail than I will. But most of the main issues in California relating to business closures and attendant layoff and job loss programs would relate to wage and hour impacts and notice requirements and obligations under WARN and many WARN acts. My colleague Carrie McAtee is going to speak to those issues in greater detail here during our program, and for now we'll just mention them. Otherwise, most employers facing potential termination processes, the concerns are often around what benefits may be available to employees from an unemployment and benefits perspective. And I've mentioned on the slide here that unemployment benefits, as we all know, are available in a much more enhanced way right now during COVID-19 based on changes under federal and state law that most of us are very familiar with. Many states, including California, also have unemployment work sharing programs, which can come into play for reduced work programs and really to help avoid job loss in many contexts. And then California also has a rapid response program intended to help both employers and employees work through employer closures and significant job loss areas. And then finally, and this is my last slide, is just an overview chart that is available through the California Labor and Workforce Development's website that provides an overview of benefits available to employees impacted by COVID-19 in various scenarios. So again, this is available through the California Labor and Workforce Development's website and is a very handy resource. So with that, I'm going to turn the program back over to Laura for a discussion of federal ADA issues.
Thank you, Kristen. I'll be touching briefly on some special considerations relating to the ADA in the federal arena due to coronavirus. And we'll start with typically an overview. The ADA prevents employers from testing, excluding, or refusing to accommodate employees based on certain health characteristics. But in the face of this spreading pandemic, the EEOC has released updated guidelines that relax restrictions on employee testing and also on exclusions from the workplace. So some of the guidelines for the employers state that an employee who has either tested positive for COVID-19 or is experiencing symptoms of COVID-19 specifically poses a direct threat to the safety of others in the workplace. So an employee may exclude that employee from the workplace or take other reasonable actions. A couple things the employer may do that they may not previously have been able to do is ask an employee if they're experiencing any flu-like symptoms, and that includes most of the symptoms that are generally related to COVID-19, like fever, chills, cough, shortness of breath, or sore throat. An employer may also take an employee's temperature. It's best to, in order to avoid claims of discrimination or retaliation, an employer should implement temperature checks across all employees at all levels rather than just one employee or singling out one particular group of employees. And it's also best to utilize a no-contact thermometer if at all possible. An employer may also require a doctor's note to return to work after the pandemic or after that person's, if they've stated that their symptoms have resided. And of course, something to keep in mind is the confidentiality regarding all of this, specifically with regard to anybody who has tested positive or even taking up an employee's temperature. That information should be all kept confidential. The employer may require anybody who tests positive under any of those circumstances to stay home. Also, an employer may screen job applicants for symptoms of COVID-19 after making a conditional job offer. And again, this is so long as the employer makes it across the board for all employees entering the same type of job. An employer may also delay the start date of an applicant who has COVID-19 or symptoms associated with it. And an employer may likewise withdraw a job offer when it needs the applicant to start immediately, but the individual has come down with COVID-19 or has symptoms of it. Some guidelines for the employees to consider is, and for you to consider for your employees, that an employee may refuse to come to work if any of the four following parameters are met. If the employee has asked the employer to eliminate the danger and the employer has failed to do so. If the employee has refused to work in good faith, meaning the employee must genuinely believe that there is an imminent danger. And if a reasonable person would agree there is a real danger of death or serious injury. And also, if due to the urgency of the hazard, the employee does not have time to get it corrected through regular enforcement channels. There's also some things to take into account with regard to accommodations. So to be eligible to receive a workplace accommodation under federal ADA, the employee must have an actual or record of a disability and some connection between the impairment and a specific need for accommodation. And in this case, individuals with heart disease, diabetes, lung disease, asthma, or a weakened immune system would all be considered at higher risk for developing serious complications due to coronavirus, and they may receive accommodations. There are some exclusions, however, and one is that according to the CDC, coronavirus alone may not be considered disability under the ADA because it's transitory, and at this point, it's considered to have a limited impact on major life activities. Also, people 65 and older and pregnant women are at higher risk for developing complications from coronavirus. However, they will not qualify to receive accommodations under the ADA solely based on their age, or if it's a pregnant woman experiencing an ordinary pregnancy. The employer in that case would have to consider, however, state and local requirements, and that's something that Elizabeth can discuss next. Also, caregivers of individuals with disabilities are not entitled to receive workplace accommodations under the federal ADA. However, they may be entitled to leave under FMLA and the Families First Act like we discussed earlier. In this case, employers also do have the right to request ADA documentation when asked to provide accommodations, but from a practical perspective, employers may want to consider whether documentation is necessary, and also perhaps to become a little bit flexible considering the situation. The employer could do something like asking for telemedicine consult with the provider, or requesting authorization from the employee to communicate directly with the individual's healthcare provider, or even approving the accommodation request without formal disability documentation, if they believe in good faith that the employee has an impairment and would need that documentation. And next, I will turn it over to Elizabeth to talk about some of the state requirements with the ADA.
Thank you, Laura. Hi again, everyone. Now I'm going to discuss some updates and considerations that have come from California's Department of Fair Employment and Housing. They've been providing updates and some summaries for employers and employees to keep in mind during this time, as they are the agency that handles California's civil rights laws, including those related to employment discrimination, harassment. So in response to the current coronavirus pandemic, the department has certainly recognized that things are changing rapidly and public health recommendations are changing and developing each day, and they vary from jurisdiction to jurisdiction. However, they are still reminding employers that California civil rights laws are still in place during this time, and they still apply and need to be considered when making decisions about how to handle certain situations that come up as, you know, we all navigate through this. And with that, they're really just expecting that employers take these public health considerations and recommendations into consideration and take a good look at how those will apply to their given workplace and the current circumstances going on with their employees, and make the best decisions that they can accordingly in order to, you know, make sure that everyone is safe and healthy during this time. The department has also given some guidance regarding reasonable accommodations. Generally, employers with 5 or more employees are required to provide reasonable accommodations to employees who have disabilities. As Laura mentioned, the question of whether coronavirus itself is a disability is uncertain. However, given that it is being considered to be a seasonal illness right now, but while that determination is still being made. It's kind of a fact-based determination of whether it rises to the level of a disability. However, if it does, then employers are required to provide reasonable accommodations so long as those efforts do not cause an undue hardship to the company. So for example, a prime example of a reasonable accommodation right now would be teleworking or coming up with an alternative work schedule that would be better for the employee during this time. However, in evaluating whether those sorts of accommodations might cause an undue hardship, you can look at the number of employees you have, your current budget, and the nature of your business or operations, and really decide the extent to which that accommodation is reasonable. Another key component here is documenting the reasonable accommodations that are being made. Employers are permitted to request medical documentation that confirms the existence of the disability and the need for a reasonable accommodation during this time, just as they would during other circumstances. However, as Laura mentioned, and similarly, the California Department is recommending that employers waive certain requirements to provide those documents, as it may be more difficult for employees to obtain them immediately and present them to the employer. Next, the employers are required to facilitate reasonable accommodations when the need arises based on someone's disability, and they can only lawfully exclude employees from their employment or related activities where that reasonable accommodation is not enough, and the person's disability might still present a concern for the company. For example, during this time, employers must continue to provide reasonable accommodations for disabilities, again, so long as that doesn't create an undue hardship. This requirement does extend to teleworking that's being done. For example, if there is a reasonable accommodation that is typically provided while the employee is in the office, that does still need to be provided while the person is now working at home. But again, if these circumstances are giving rise to some sort of hardship for the company, then the department is nonetheless recommending that the employer and employee work together to try to develop another alternative approach that might work better. And next, I'm going to turn it over to Kristen again, who's going to discuss remote work aspects.
Thank you, Elizabeth, and hello again, everyone. Now we are going to talk about aspects of the current pandemic that involve remote work or work from home, which has, of course, become a new norm for many types of employees in light of stay-at-home orders and shelter-in-place orders that are in effect around the country and, of course, in California. Here on this slide, which is the only slide that we'll cover in this segment, we've listed a series of issues for consideration for those employers with employees in California working at home. Some of these issues are practical and they relate to the effectiveness of employees working at home, but others relate to legal requirements and risks that are prominent in California and are especially so now that work from home is mandatory and not optional for many. This is one of the multiple impacts of COVID-19 that have been effectively forced on employers as part of the effort to slow the spread. One of the most important issues listed on this slide relates to business expenses and reimbursement, which is the fifth bullet on the list. While some of the issues we're going to discuss are only relevant to non-exempt employees, this issue applies to all employees, regardless of classification, who are required to work at home during the pandemic. As most of us know, California has a statute, Labor Code Section 2802, which requires employers to reimburse their employees for reasonable and necessary expenses they incur in the direct consequence of discharging their job duties. The purpose of the statute, as we know, is to prevent employers from passing their operating expenses on to employees. This has long been an obligation that's been a tricky one for California employers to navigate, and one that's prompted a lot of action litigation in the California courts, mostly relating to cell phone expense and to mileage. So the obligation isn't new, nor is the risk of litigation. But with employers now requiring employees to work at home, just as a necessity of the crisis, the arguments against the necessity of certain business expenses are largely gone, and the likelihood of class litigation is significantly heightened in this area. The required nature of work from home and all that it entails for certain types of workers will necessarily create common issues more likely to be certified by courts. So we're truly likely to see a rise in class litigation in this area. All of this is to say that employers with employees required to work at home in California should carefully review all categories of workers and evaluate what types of expenses they're necessarily incurring to do their jobs, and to develop an approach for reimbursement if one is not already in place. This is likely to involve creation or revision of existing policies or guidelines that companies may have around remote work, specifically defining what types of expenses are allowed, which are not, which will be reimbursed, which will not. Important to note concerning required cell phone use and need for internet service, that it's not necessary for an employee to actually incur an additional cost beyond what they would ordinarily pay for such service for their personal needs in order to prompt reimbursement. In other words, the obligation is still there to pay some reasonable percentage, say of cell phone expense or internet connection, which is of course not undefined in the case law, what that phrase reasonable percentage means, for the business necessitated part of the cost to employees. So one approach for consideration that may work for some employers is to provide a fixed amount stipend to account for necessary work from home expenses like cell phone use and internet service. But if this approach is taken, it should also be supplemented with an expense request form that's made available to employees to use to submit for additional reimbursement if the stipend amount is insufficient or if different or additional expenses are incurred. And then those requests can then be considered by the company. One final note on expense reimbursement: employers should not rely on the availability of expense reimbursement forms or submissions alone. In other words, just relying on a form itself. If employers know that their work requirements are creating business expenses for their employees, they cannot not provide reimbursement and then just say, we had a process available, but X employee didn't submit for reimbursement. This is just a really risky kind of duck one's head in the sand approach that courts find unconvincing in this area. And that will increasingly be so when remote work is required and not optional. Another important issue to mention concerning work at home, so this is moving beyond expenses, concerns non-exempt employees. Important for employers to mention that all of the typical wage and hour concerns for non-exempt remote workers, including the importance of recording and paying for all time worked, paying overtime and double time as necessary, providing timely final pay, and providing for meal and rest periods. So all of these same issues that are present for us in the regular workplace are present for non-exempt employees in a home or a remote workplace. And then finally, just a few other issues to flag. Those would include around remote work, updating existing policies to account for the current environment and the fact that employers likely have additional categories of employees working at home who weren't doing so previously. So our existing policies or guidelines may not fully account for the types of workers we have at home now. Also, making sure remote workers understand that company policies apply to remote work environments just as they would if one was working in an office or a work site. Also, acknowledging for employees the importance of a safe and secure work environment at home, knowing that OSHA and work comp requirements are present at home as well. This can include defining work hours, workspaces, etc. Bearing in mind, as we just heard from Laura and from Elizabeth, ADA obligations present at home as well. And then finally, this is beyond the scope of what we can cover here, but being mindful of cybersecurity and potential data breach risks that can come into play in a greater way with home workers. So I will end there, and Carrie now is going to walk us through a discussion of California wage and hour issues. Thank you.
Thanks, Kristen. This is Carrie McAtee, and we've already talked about a number of wage and hour issues that are implicated by the current COVID-19 pandemic, including those relating to furloughs and working from home. But just wanted to highlight or punctuate a few sort of specific wage and hour issues that are somewhat unique to California. The first is the definition of hours worked that I think could be implicated in connection with either working from home or a furlough or a reduced hours work week. Hours worked in California, as many of you on the webinar may know, are defined more broadly than they are under federal law and the law of many other states. The definition of hours worked in California is the, quote, time during which an employee is subject to the control of an employer and includes all time the employee is suffered or permitted to work, whether or not required to do so. California courts have interpreted that quite broadly, and so I think employers in about 3 different areas need to be mindful of that. One is the sort of teleworking, remote working that Kristen mentioned, and making sure that employers are accurately and thoroughly accounting for any hours worked as defined in California for those who are working remotely. 2 and 3 would be thinking about furloughs or reduced schedules. I know that in this environment, many employers already have implemented those kinds of measures or are considering implementing temporary furloughs or reduced schedules. And I think that the breadth of California's definition of hours worked really makes it important to think very carefully about that as it might relate to furloughs and reduced schedules, and the importance of establishing a protocol and clearly communicating it to employees. So, for example, a protocol that's designed to prohibit both exempt and non-exempt employees from doing any work at all during a furlough period or on days or parts of the week where they're not to be working. For example, advising all employees that they're not authorized to perform any work during a furlough period or on a day off, cutting off access for employees during a furlough period, and instructing supervisors and coworkers, internal and external customers, that they are not to contact any employee during a period of time where that employee is on a furlough. And then, of course, if an employee disregards the instruction, or if an employer or any manager requests that an employee perform work, then the company would have to pay that employee. And again, that's true for non-exempt folks, but it's also true for exempt folks. And if someone is exempt and does any work at all in a work week, then they would need to be paid for the entire work week. So if you've got exempt folks who are out furloughed for a week or more at a time, I think extra important to make sure that they are not doing any work during those weeks. Kristen talked about this, so I'll just touch on it, but just the obligation to reimburse an employee for all necessary expenditures or losses incurred by the employee. California has heightened requirements for that. And so good to be mindful of that along the lines Kristen mentioned for purposes of folks who are working remotely. Another unique issue to California relates to a question about mandated usage of vacation or PTO. I think many employers right now are struggling with how to handle vacation and PTO, whether to require employees to use it during furlough periods or downtime, shutdowns, or whether to prohibit employees from using PTO or vacation during a furlough, for example, which is designed to be a temporary cost-cutting measure. One thing to be aware of in California is that there is a DLSE internal memo from, I think, about 15 years ago that suggests that if an employer wants to mandate vacation usage, in other words, require an employee to use vacation during a certain time period, that 90 days notice would be required in order to do that. Again, this is a DLSE internal memo, so questionable, how much weight it has, but I think an important thing to mention if you're thinking about mandating vacation usage. And then finally, want to mention final pay obligations. As we know, federal law does not mandate payment of vacation or PTO at the time of termination, but in California, that is required. That once someone is quote unquote discharged, they are due their final pay, which would include accrued but unused vacation or PTO. This is somewhat complicated in the context of a furlough or any kind of a temporary layoff, because there's a question around, to what extent is a furlough or temporary layoff a quote unquote discharge that would trigger final pay obligations. And the California Labor Commissioner, DLSE, has taken the position that for any temporary furlough that is planned to last longer than the current payroll period, the last day worked by the employee should be considered a quote termination or discharge which would trigger the obligation to pay all wages due on the last day worked. There's actually another opinion letter that says the final pay is due if the furlough lasts more than 10 days or does not have a definite return to work date. And of course, failure to pay final pay on time in California can subject an employer to liability for waiting time penalties, up to 30 days of pay, as well as other penalties. So I think it's important for any employers who are considering temporary layoff measures or furlough measures to be thoughtful about these letters, which I think read together suggests that if there's a return to work date within a normal pay period and the employee returns to work, the layoff does not constitute a termination. But if there's no return date, if the temporary layoff lasts longer than 10 days or the normal pay period, an employer may be in a situation where they have to do a final payout of vacation as well. And of course, these opinion letters are not authoritative, but some courts do find them persuasive. And so I think many employers will be struggling with that issue in light of the COVID-19 crisis. Next up, Bill Martucci is going to speak briefly about workplace safety and health considerations.
Thanks so much, Carrie, and thanks for your remarkable insights on the wage and hour implications. Well, unlike the complexity of wage and hour and Kristen's wonderful discussion about working remotely, the safety and health considerations are relatively consistent with existing laws. So we look to OSHA, and we look to the California Division of Occupational Safety and Health, and we begin very simply with the General Duty Clause, which of course essentially provides that an obligation exists by the employer to provide a place of employment which is free from recognized hazards or likely to cause death or serious physical harm. What's really intriguing in this context is the fact that so many of us are now working remotely. And as Kristen mentioned, a number of those issues in the context of the new expansive remote workplace, what about safety and health considerations there? And really, there's not a great deal of guidance, but let me give you 2 or 3 kind of specific examples and then the more general guidance. With respect to personal protective equipment and the standards that apply there, often what's referred to are gloves and eye and face protection and respiratory protection. Well, in light of COVID-19, that seems remarkably familiar to us. And as recent as this morning, there was an interview on NPR with Dr. Copeland of Emory University, who's the former director of the CDC in Atlanta. And essentially, the topic was about masks and whether masks are effective, should they be used. And I think it's fair to say that what Dr. Copeland advised is that if you have a mask and you can use the mask, that's worthwhile. But the great need, of course, is in the medical field at this point, and providing those who are healthcare providers with whatever equipment we have at this point. The reason I mention this is because I think we're going to have more and more questions because it's ever unfolding in terms of what is considered the appropriate protocol. So when you think about the General Duty Clause of OSHA and generally as applied in California, we have to be really comfortable to be ever evolving on this. With respect to whether COVID-19 could be a recordable work-related injury, the basic rules apply that if in fact this occurred in the workplace or became known in the workplace, then the safest guidance is to consider that a reportable event. With respect to the guidance that you can look for, both the California Commission and the Federal Commission have some very helpful guidelines. They're not remarkably specific. They repeat many of the basic good practices one would hope to have. But for example, the OSHA booklet is 32 pages. It's pretty helpful. It's entitled Guidance on Preparing Workplaces for COVID-19. California has a number of similar aspects. And 2 thoughts to leave you with. As we think about the remote work arrangements, perhaps making these guidelines ever more available to all of us who work for a given employer would be worthwhile. And second, the idea that perhaps whatever medical protections we have, that we consult with those advisors and get their guidance, and perhaps to the best extent we can, make those open lines available to those that are working with us might be helpful as well. Well, now we looked at some really delicate, difficult questions under WARN and California's mini WARN, if you will, and Carrie McAtee will guide us.
Thanks, Bill. I'm just going to touch very briefly on the Federal WARN Act and focus a bit more on California. But the key takeaway on the Federal WARN Act is that there must always be at least 50 employees who suffer a, quote, employment loss at a single site of employment during any 90-day period. That would have to be the case in order to trigger any federal WARN notice requirement. Importantly, for I think our purposes, that a layoff or a furlough lasting less than 6 months does not constitute an employment loss under WARN. And also, if anyone has an hours reduction, the hours reduction has to be at least 50% hours reduction in each month of 6 consecutive months in order for federal WARN to be triggered. So accordingly, an employer could temporarily lay off or furlough more than 50 employees at a site of employment as long as it's less than 6 months. That won't trigger any WARN notice obligation. Perhaps not surprisingly, California is different. And 2 major differences in California WARN to highlight. Number one, it does cover short-term layoffs that the Federal WARN Act does not cover. Under Cal WARN, it's been interpreted fairly recently by a California Court of Appeals that a mass layoff includes a layoff of at least 50 employees during any 30-day period, with the layoff being any, quote, separation from a position for lack of funds or work, and there's no requirement of any minimum duration, like the 6-month minimum duration that is expressly stated in federal WARN, but not in the California WARN Act. That case I mentioned is from 2017, and that involved a situation where the employer was temporarily furloughing folks for 4 to 5 weeks. And the court there noted that, Cal WARN does not have a minimum duration for an employment separation, and therefore Cal WARN notice would be required. And the other unique aspect of Cal WARN is that it does not include any unforeseeable business circumstance exception like federal WARN does. And so that leads us to the executive order that was issued by Governor Newsom a couple of weeks ago that temporarily suspended Cal WARN. This happened, I think, maybe 48 hours or so after the first round of shelter-in-place orders that I think Jason Richardson will be talking about later. It is retroactive to March 4th of 2020, and it applies to all covered employers who order a mass layoff, relocation, or termination otherwise covered by Cal WARN that was, quote, caused by COVID-19 related business circumstances that were not reasonably foreseeable as of the time that notice would have been required. Now, importantly, anyone does not excuse employers from issuing a Cal WARN notice. Employers who are covered by Cal WARN would still need to issue a Cal WARN notice as soon as practicable. There are specific requirements in the governor's executive order that employers must meet when issuing the Cal WARN notice. So employers aren't off the hook in issuing notices. They just may be relieved of the 60-day notice requirement if they meet the certain specific conditions that are outlined in the executive order. Next up, we're going to turn to Mark Campbell to talk about the CARES Act that was just passed last week.
Thank you, Carrie. Again, a deep thanks to all of our attendees this afternoon. As most of you know, on March 27th, the President signed the Coronavirus Aid, Relief, and Economic Security Act, also known as the CARES Act. The Act is some 854 pages of light reading and broken down into 6 primary titles. The 2 I wanted to focus on, I am mindful that we're coming up on the hour, so I will do this quickly, are the first 2 titles, Keeping American Workers Paid and Employed, and Assistance for American Workers, Families, and Businesses. We literally could spend hours trying to understand and unravel many of the provisions of the CARES Act, but I will let you do that all in your free time. So let's start with some good news. The CARES Act provides for several potential benefits and maybe some deferred benefits for employers. We've heard a lot leading up to my presentation about the obligations on the employer and during these uncertain times, and many of them are onerous. So I thought I would shine a little bit of sunlight and sunshine onto what was otherwise kind of a depressing state of events. So let's just start with some of the good news. There are a couple of provisions within the CARES Act that are particularly helpful to employers. The first relates to the employer payroll tax delay. And what that provides is that employers are entitled to defer the typical 6.2% share of Social Security taxes that they would ordinarily pay either on a semi-weekly or monthly basis for up to a couple of years. And the way that works is, in order to assist employers with sort of their immediate cash flow needs, the CARES Act allows for that deferral of Social Security payments otherwise due between March 27th of 2020 and December 31st of 2020 to be paid in two separate payments or installments. The first installment, which would represent half of the otherwise due Social Security taxes, can be paid or deferred until December 31st of 2021, and the second half deferred until December 31st of 2022. So for companies that are struggling with cash flow issues currently, this provision provides some important relief. Relatedly, there is the payroll tax credit, which is particularly helpful for employers. And rather than a deferral, this is an outright credit for employers. The employee retention credit is fully refundable as opposed to a deferral. It applies up to 50% of wages up to $10,000. So the amount of the per employee payroll tax credit is $5,000 per employee for wages paid during the period indicated on this slide, March 12th through January 1st of 2021. Eligible employers for this credit are any employers whose businesses were fully or partially suspended in 2020 due to government orders associated with COVID-19, or that experienced a significant decline in gross receipts over this same period. Significant decline in gross receipts is typically established when the business's gross receipts in a calendar quarter in 2020 are 50% or less than 50% of the gross receipts over that same period in the same calendar quarter in 2019. So for purposes of the credit, the qualified wages are those wages paid during the period of economic hardship, and they'll vary depending on whether the employer has more than 100 full-time employees or not. For those with more than 100 full-time employees, qualified wages are those paid to employees when they're not providing services due to COVID-19. For those with 100 or fewer employees, virtually all the wages will qualify for the credit. The IRS has a very useful frequently asked questions link on its website in its newsroom. I suggest if you're interested in the credit, employee retention payroll tax credit, that you visit the IRS website to see some of that information. The next element I want to discuss of the CARES Act isn't really necessarily an employer benefit, but I wanted to point it out because there is unemployment assistance for those who ordinarily would not qualify for unemployment assistance. So this includes independent contractors, gig workers, freelance workers, and the self-employed. So there may be those of you out there who would not otherwise qualify for unemployment benefits, and I just wanted to point out that this opportunity exists for those who are in that category. So let me move along. There's also some clarifications. I'm not going to spend a lot of time because most of this was covered earlier. The major clarification in the CARES Act was just simply to make clear that the aggregate limitations on the FMLA leave and sick leave payments are per employee. So it's pretty straightforward clarification in the CARES Act, but apparently there was some confusion over that. So it was clarified in the CARES Act. So let's talk about what I think is probably the most important aspect of the Act, and in particular for companies with 500 or fewer employees. And this is the Payroll Protection Program. Under the CARES Act, there's $350 billion set aside to help small businesses keep their workers employed. The program is designed to really get cash in the hands of small businesses who are suffering with really very little red tape that ordinarily exists in a typical SBA program. The Payroll Protection Program is really designed to incentivize the employers to keep their payroll going, even if work is slowed down. And as you'll see, there really are tremendous incentives to do so. And the most important incentive is that these loans may be forgiven if the borrower maintains their payroll levels during the course of the crisis. For many businesses, this is going to be a no-brainer. The application, as I'll show you in a moment, is 2 pages. There are some financial records you'll need to provide, but generally speaking, the process is fairly straightforward. And even to the extent the loans are not forgiven, they carry a very reasonable 4% maximum interest rate and have a 10-year maturity. So again, very beneficial for small businesses. So eligibility for the Payroll Protection Act loans are small businesses with fewer than 500 employees, a small business that would otherwise meet the SBA's size standard. And for nonprofits, this is particularly important, 501c3 companies. So if you're part of a 501c3 company, either through your own work or through boards you sit on, this is really important because these companies in particular are struggling at this point in time. There's some others you can see here that are covered, but I want to make a particular note that those in the accommodation and food services sector with employees that might have more than 500, the good news for you is that the employee count is done on a per physical location basis. So if you operate multiple locations, the SBA loans are available on a per location basis, such that you could qualify. And so this is really important for our food services industries, our hotel industry, et cetera. So I wanted to make special note of that. These loans can be up to 2.5 times the borrower's average monthly payroll cost. Again, not to exceed $10 million. Included payroll costs, as you can see here, are your traditional salaries, wages, commissions, and tips, but also include certain employee benefits, and group health care benefits and things of that nature. But there are certain excluded payroll costs. Again, compensation of an individual who is paid over $100,000 the amount in excess of $100,000 would not be part of that. Payroll taxes would not be part of the payroll calculation, and you can see the others listed here. Sorry to be moving along so quickly, but I am trying to be mindful of the time. So the loan forgiveness, which can occur 8 weeks after the loan origination, is pretty remarkable. A borrower who is eligible for forgiveness can effectively have the entire amount of the loan forgiven, so long as the proceeds from the loan were used for payroll, interest on mortgage obligations, rent obligations, utility obligations, and some other wage types of wages. If you don't spend the money on those things, in other words, you spend it on expenses that are outside the eligible expenses, it's still not terrible news. There can be a reduction of the amount of forgiveness, but there is still some entitlement to forgiveness, and there's some calculation of how that's done. Just wanted to finish up again on the application process. Applications are being accepted starting tomorrow. Again, the application is very straightforward. It's 2 pages. Unlike most SBA loans, there is no personal guarantee required, which again is going to be really important for small businesses. There are many other requirements that you may want to look at. You can see those on the SBA website, in the Act itself, or there's more information at in the Treasury Department website. But the application, once completed, will be submitted to participating lenders, and most of the major banks are participating. So if you have a banking relationship, I would reach out sooner than later to get this process moving, because I imagine there will be a line of people looking to take advantage of what is a very important aspect of keeping our workforce in place. So thank you all for your patience. I'm going to pass it on to Jason Richardson, who's going to talk a little bit about shelter-in-place orders.
Thanks, Mark. My name is Jason Richardson. I am an attorney at the San Francisco office of Shook, Hardy & Bacon, and here to talk a little bit about California shelter-in-place orders. And at the outset, I just want to say that I'm particularly excited to be giving this particular presentation to an ACC event. I had an opportunity as a seconded attorney to work briefly in-house here in California. And one of the things that really struck me about what makes in-house work so challenging is the fact that you as in-house attorneys are not only dealing with complex legal issues, but at the same time you are answering to business interests and finding a way to make risk-based determinations for how to keep the doors open where you work in light of those particular legal issues. That can be an incredibly difficult thing to do under the best of circumstances. And as everyone on this call is no doubt aware, we are not dealing with the best of circumstances at the moment. What we have right now in California, as everyone is aware, are numerous orders from multiple jurisdictions with different language, different definitions, different exceptions, different penalties, and to the extent there may be expiration dates, different expiration dates. For when those orders sunset. Just to give you a brief snapshot of what we've been dealing with just in the last couple weeks, and only a partial snapshot at that. In Los Angeles, both the city and the county entered different shelter-in-place orders with different language and exceptions. And here in the Bay Area, 7 Bay Area counties on March 16 entered shelter-in-place orders. Then, subsequently on Tuesday of this week, those orders were extended and also substantively expanded in terms of some of their coverage. In addition to that, on March 19th, the governor issued a statewide shelter-in-place order, and 3 days after that, the state public health officer issued further language clarifying that, and that state order incorporated a DHS memorandum, which was otherwise non-binding, but became binding, and that memorandum was subsequently amended on March 28th. So needless to say, this is a tangled web of orders to make sense of and to tackle. So how do we do that? Well, here are some of the ways that we can approach this problem. First and foremost, it's important for us to think about which jurisdictions apply to our businesses and our employees and which orders apply. So you'll want to take stock of where you have employees, where you have facilities, and which counties orders apply and which do not. That first step actually is not as simple as it may seem at first glance. Even for those of you who operate solely in counties where there is no specific county order, just making sense of the statewide order that Governor Newsom entered is its own set of challenges. So as I alluded to earlier, that order was issued on March 19, incorporating a Department of Homeland Security memorandum. However, on March 22, it was further clarified by the state health officer and done so in a way that really anticipates some California-specific businesses. For example, carving out exceptions for cannabis retailers and also for, quote, workers supporting entertainment industries, studios, and other related establishments. So just looking at the governor's order itself doesn't necessarily give you the full picture. And again, even the federal DHS order was subsequently amended on March 28th, and that was done to include, among other things, the real estate industry. So once you have a sense of what orders apply to you, at what jurisdictions and at what levels, each of you are going to need to take stock of how to make that risk-based determination. And that's going to be business to business specific, and it's going to be very case specific, a decision based on how does your business fit or not fit within what is considered essential infrastructure pursuant to the guidelines that do apply. With that in mind, I also want to flag that just making that determination alone is not the end of the analysis. You're going to, even if you're deemed to be essential or critical infrastructure, these orders, especially at the county level, contain guidelines for social distancing. In fact, the San Francisco County order that was issued, again, just Tuesday of this week, expanding the previous order to May 3rd and making some substantive changes as well, includes, quote, social distancing protocols that need to be posted at every place of business. And in addition, substantively, these county orders largely include guidelines that even essential businesses must maximize the number of employees who are working from home. So those are all things to consider as you make these risk-based determinations to try and keep the doors open and try and comply as best as possible with these orders. In addition, you're going to want to be considering the penalties. Most county shelter-in-place orders have usually a minimum penalty of up to about $1,000 and sometimes a short amount of prison time available. Usually that won't be a concern depending on the risk-based determinations that you make. One potential bigger concern is the risk of private civil litigation. However, in the event, arguably, you haven't complied and there's been disease transmission, that can be a huge threat. And with that in mind, it's important to consider the fact that from a common law standpoint, there have already been lawsuits filed on March 13th before any of these shelter-in-place orders were ever entered. We had a lawsuit filed in the Central District of California based on the Princess Cruise Lines ship that was outside of the harbor here in the Bay Area for a while. And as many of you know, the private civil litigation risk from a financial standpoint can dwarf governmental penalties. Something to keep in mind also is the interplay between those common law considerations and these shelter-in-place orders. One of those considerations is the negligence per se doctrine. The failure to exercise due care is, of course, presumed under the California Evidence Code if someone violates a statute, ordinance, or regulation. So in the event litigation does occur, a lot of these orders are going to make it much more difficult to later on make the argument that due care was in fact exercised. Now, any plaintiff suing will, of course, need to establish causation and damages, and that will be fact-specific, but that is something to consider as well. The final thing that I would offer on these shelter-in-place orders from a substantive standpoint is to continue to monitor this space. As I alluded to earlier, this situation is changing incredibly rapidly, and the orders that apply last week are very unlikely to be the same orders that apply 2 weeks from now. So with that in mind, that's an overview, obviously not a catalog of every single shelter-in-place order and all of its exceptions and guidelines, which would take hours as opposed to minutes. But those are some of the important things to be considering as you're making your own risk-based determinations to try and comply in good faith and do the best you can for your own individual businesses. One last thing that I would really want to highlight before we move on is the issue of attorney-client privilege and how important it is to remain cognizant of that throughout this process. As of course we're all aware, attorney-client privilege exists so that we can provide unvarnished advice to our clients and do so in a safe space. I think that just takes on an outsized importance in the face of COVID-19 issues and liability and the shelter-in-place orders as we try to comply. So I would really encourage everyone to take all the steps you can to make sure, number one, that privilege does attach where it should, and number two, that those people who are involved just really jealously guard that privilege and do not do anything that could be construed as a waiver of it. Because we as outside counsel have all seen, the emails where someone thought something was privileged or weren't quite taking the steps they should have, and those make all the hairs on the backs of our necks stand up. So with that in mind, I will pass it back to Bill Martucci to talk about leadership strategies in the time of COVID-19.
Well, thanks so much, Jason. And as we wrap up, I want to thank everybody for their participation who's been with us today. What we're going to do on questions and answers is, if you have questions, please feel free to raise them, and we will get back to you and talk through it, and that'll be without charge, and it would be our privilege, frankly, to work through it in these difficult times. We think, in all sincerity, we've got pretty good answers to the questions that have been raised, but I think to go through them would take a little more time and be a little more nuanced than we have available for us right now. So if that works for you, that's great. If it's comfortable for you to send me an email at wmartucci@shb.com, I'll be sure to coordinate it, and we will get back to you fairly soon. I don't think it'll be today, but I think it might be tomorrow or Monday, and I think we've got a very good handle on the kinds of issues that you've raised. They kind of fit into two categories. One are kind of more specific situations in a given workplace, factually driven. The others are more, how does the legislation impact this precise situation? So I think they can best be addressed in a brief call, and it would be without charge, and we'd be pleased to do that. We really cherish our relationship with you, and particularly in these challenging times. Well, as we close out, we think about leadership strategies, and these key bullet points just came from a presentation from one of our clients in the financial markets in New York. And I just thought the straightforwardness of it was rather striking. The fact that everyone is putting together a crisis playbook that could not have been otherwise anticipated, at least could not have been anticipated until a few months ago. And that, frankly, for virtually all of us, there are new financials. And if you're publicly traded, what happens on the street and how you're valued remains to be seen. If you're smaller and private, all those issues, our heart goes out to all of you in terms of how tough those are and the key role you play as corporate counsel. And so as we think about this, in addition to getting back to you with the good questions that you've raised, we'll also kind of share with you some frequently asked questions and be able to do this in a fairly straightforward way. So we will let you go. We thank you so much for participating with us. We want to be helpful to you, particularly in this tough time. I do want to thank my colleagues who I appreciate so much, who jumped through many efforts to kind of come together and provide this information. Hopefully the slides alone are a great resource. We will follow up further. Have a great day. And again, we appreciate you so much and feel like there's a special connection from this effort together with the ACC for Southern California. Take care. Thank you. This concludes our program.